Good evening, everybody. Welcome to another IBIL Spectacular. The great thing about being at UCL is if you ask the best people, they always say yes. So all I'm here to do is to welcome you here, and I'll say something at the end. And now I'm immediately going to hand over to Vivien, who is in charge of this uncontrollable mob.
Thank you, Robin. Well, good evening, everybody. Welcome to this event. The phrase EU exhaustion has taken on a slightly different meaning over the last few months, but we're taking it back to its original technical meaning this evening. And we have four experts who are going to help us understand the current state of where the law is. I'm going to introduce them briefly. The first speaker is William Bowes, who's General Counsel and Director of Policy at the Publishers Association, and he's going to give us a short overview of how cultural and linguistic factors affect territorial segmentation of the book market and how the copyright exhaustion framework works for authors and the publishing industry in general. Next is Dr. Christopher Stothers, to my immediate right. Chris is a partner in the London office of Freshfields Brookhouse Derringer and also a visiting professor here at UCL Law Faculty. And he's going to talk about how EU parallel trade functions, especially in relation to pharma repackaging, how this has been affected by recent cases and the Falsified Medicines Directive. Then on my left is Professor Irene Calboli from Texas A&M University School of Law. She's going to focus on recent US developments and then discuss free trade agreements a little, and finally whether trademark law can be used to provide a way to work around the rules on international copyright exhaustion. And finally, on my far left is Matthew Cope, who is Deputy Director of IP Enforcement at the UK Intellectual Property Office, and he's going to cover the government's current position and talk a little bit about the legislation in place for a no-deal Brexit. I haven't heard the news today. I don't know what the odds are on that happening, and the research that's being carried out by the office to inform the longer-term position. They'll each speak for about 10-12 minutes, and then I'll be asking for questions from you if you have anything to ask our speakers. So let's kick off straight away. Thank you.
Thank you very much for the introduction and for inviting me to speak here this evening. I'm not sure what the views in the room are about whether national or international exhaustion is the right model, but I hope in 10 minutes' time or so you'll have an understanding of why it is that there are many reasons why it's important to have distinct markets for books, and that perhaps these issues are things that this country ought to think very carefully about in the weeks and years ahead. Why is it that books matter to society? Well, there are lots of reasons why. They play a key role in all of our lives, right from our childhood and our education through our professional careers, many of us studying or practicing as lawyers in this room, of course. But also the culture, morals, and religion of this country, in any country, and the administration of justice, and our criminal system as well. So books are a really important thing, and books are very difficult things to get right, and the books that this country needs might be very different from the books that another country needs. As it happens, we're really rather good at making books in this country. The UK has books at the heart of our national life and our national culture. They power education and learning. They fill our public libraries, provide content for creative industries, and you see there the impact that books have on film and theatre. It's incredible. They fuel our science and research, and they support most of the industries that this country is good at and that it relies on to pay up for our public services. But in addition, the English language in our books also project our soft power and influence around the world. And the stories that we see of children growing up reading Harry Potter and learning from English textbooks are incredibly motivational for publishers every day. But this country also exports more books than any other country in the world, more than the USA, more than Germany. This is something we genuinely lead the world at, and at this precise moment in our national history, that's something that one would think one would want to be maintaining rather than putting at risk. Many of you may think that national exhaustion is a protectionist measure and that businesses use it in a cynical and commercial way. Well, British publishing is anything but protectionist. We operate right at the heart of a global free market. We're of course supported by strong copyright in this country, but we believe very passionately in freedom of contract, both with our authors and our customers. We're passionate advocates for the zero tariff regimes at the WTO on books. Unlike many countries around Europe, we have no fixed book price in this country, so we're fully open to price competition. Our shareholder base for many of the best British publishers is extremely globally diverse, both in the EU and in the US and right around the world. And the reason we're so great at publishing in this country is not just because there happen to be many great British people who are good at publishing, but because we import the best talent around the world and use that to create the best books, which we then export back. We've also been exposed to big tech right from the very beginning. Amazon was a bookseller. That was its original role, its original business. And right since the mid-90s, we've been engaging with big technology and working with them to try and build book markets and try and sell our products right around the world. So although digital is changing our landscape, our interest in national exhaustion and a strong copyright framework is not about protecting our markets. And of course, we're utterly reliant on copyright. And here we begin to see why territorial copyright and national exhaustion is so important to us. The first thing to understand is that publishers don't have any rights of their own. All we do is share those of our authors. Copyright provides that the author is the original owner of a literary work, and they and their agents enter into very difficult negotiations with us to determine the price and the terms on which we can sell. And it is authors and their agents and not publishers who very often decide to divide markets up on a territorial basis. It is their strategy, their tactics, they're the ones who decide to enter contracts with multiple publishers rather than very often just one. And we work with them to respect their wishes and to exploit their rights in the way that they ask us to. So even if the government were to ask the publishing industry to change the way it worked, they would be asking the wrong people. We, of course, then transfer copyright further down the supply chain to all the global online distributors and retailers, both physical and digital. Then, of course, onto the end users, where you will take a license, whether the imprint page on your book or an end user license with an ebook. And then, of course, very often, actually, our customers are not the end users. Our customers might be a school or a library or a university such as this that is buying content on behalf of the people who ultimately use the product. So the copyright supply chain is complex. It is territorial in its nature at birth, not by our choice. And we work as well as we can to try and make that work for readers all around the world. This is just one example of a territorial rights matrix in one publisher. These things are complicated. Some markets are exclusive, some are not, and they vary from publisher to publisher, but this is just one example of how they try and manage their territorial rights. It's difficult, and breaking it up would be incredibly difficult, risky, and cost a huge amount for everyone involved. The business of publishing is perhaps best understood as a series of micro venture capital investments by publishers in authors. We try and identify the right talent, and we try and understand which books are going to work. But in all honesty, we don't often get it right. And however much we feel passionately and strongly about a book, sometimes books take off and sometimes they don't. And it is the ones that take off that subsidize the ones that do not. And therefore, we have to have the confidence of a strong copyright framework to keep taking those risks and making those investments, because it's the one that you don't think that's going to work is the one that does. Many of you will know the apocryphal stories about Harry Potter and the number of publishers that turned her down, and even the very small amount that she first obtained. But that great success story is perhaps the best example I can give you of that. But national exhaustion also enables us to create the bespoke versions of products for each market, so we can have the right version of the book. Whether you need a novel that has the right version of English for this country rather than perhaps American English, whether you're a law student who needs the laws of this country rather than another country, whether you're a doctor wanting medical information that complies with UK regulations or another, or you're a student trying to have books that work for one particular curriculum or another. There are many, many good cultural and legal reasons why you might need that. And it's very, very important that we're able to publish this broad range. It's not just us who believe this, it's authors as well. The quote at the bottom there from Nicholas Solomon, who's the Chief Executive of the Society of Authors. This is a really important issue. Author pay is incredibly important for the diversity and national culture of this country, and we really do need to be able to support them. You may hear an awful lot from other speakers tonight about the EU and of course the implications of that. For us, this is not an intra-EU issue, this is a global issue about the UK's trading relationships with other countries. Because if we were to go to an international exhaustion model without any other kind of provision that enabled this to carry on, we may very well see our book market here devalued, flooded with imports of books and versions of books not created for our laws or our cultures. We may very well see US publishers, as they've already said they hope and plan to do, to take back the EEA market from UK publishers, reducing tax revenues here and jobs. And we will also have much less confidence in creating editions of books for developing nations, and the prevalence of English-created textbooks in classrooms around the world is a huge soft power benefit to this country. So there is a real risk in all markets. Government may see fewer high-quality books published in this country, which may have many effects, including seeing us becoming a net importer of textbooks for our schools. Fewer British stories will be told, the dilution of our national culture and the diminution of British film and theatre. The globally mobile book ecosystem may decide to move to another country, and there'll be fewer skilled publishing jobs in the UK with fewer tax receipts as a result. Readers, often price is equated with the consumer interest, but readers will see fewer quality books to choose from, fewer editions especially tailored to their need, which will discourage reading, which research shows is one of the biggest drivers of social mobility and education in this country. We also see from the Kurtzsang case, which others may refer to later, that the impact of that for developing countries is disastrous, because what happens is prices rise to deal with the risk. For us as publishers, it would be extraordinary for the country to compound the negative impact on business of Brexit by making it an even less attractive place for this to be the global home of publishing. Why put a world-leading industry at risk here? Authors will also suffer because they will have fewer publishers in this country identifying their talent. And for non-UK authors, the UK will send a signal that their opportunity to take part in our book market is curtailed, unless they decide to publish here first. And my big question then is why? Why would we have this policy inconsistency from an intellectual property office which does a great job championing and protecting its creative industries? They rightly talk about our gold standard copyright framework, but this is a key part of it. They fully acknowledge the creative industries as a key driver of soft power and economic value for this country. It's one of our major leading industries and one of the chances we've got of continuing to be successful in the world. Why put that at risk? I've also been heavily involved with people at the IPO doing fantastic work in trying to promote the value as part of the digital single market package, trying to deal with the value gap, trying to ensure that creators get fair pay online, trying to stop piracy, trying to crack down on all these things that an international exhaustion model would encourage, potentially. On the 22nd of June 2016, no one was thinking or saying that this was a policy problem that needed solving, at least in relation to books. So why change this policy for books now? And if the answer to that, which I often hear, is it's all to do with the NHS, well, just one publisher has told us they will lose more money than the NHS have estimated the cost will be increased by this measure. So I think it's really important that we look at this in an economic way as well. I end with just by comparing the two. National sounds closed, international sounds open, but the national framework for books has provided a platform for the UK to lead the world in this industry. A move to international will devalue our book industry and mean the world's best publishing talent will simply choose to relocate. I'm very open-minded as to looking at other solutions for this. It's legally and practically conceivable to think that things other than national exhaustion will enable this huge success story to continue. But surely, whatever this country wants to be in the future, it wants to continue to be the world's publisher. Why should we let Brexit put this at risk? Thank you very much.
Thank you very much, William. I think we'll have all the speakers first and then take questions. So over to you, Chris.
Thank you, and thank you for that explanation. I'm afraid I have no slides today. 20 years ago, as a penniless student, I went to a talk by a very famous barrister, now a judge, and he told us all about the Tesco and Levi case and the Davidoff case. And the press was full of rip-off Britain and Fortress Europe, and how this was a terrible EU rule that was blocking our access to cheap goods from America. And as a penniless student, I was outraged. This is terrible. How can I be right to be used in this way? This makes no sense. 10 years ago, I'd written a book about it. And I went to talk to another very famous judge, now no longer a judge. He told me, exhaustion, that's boring. There's nothing interesting to say about exhaustion. which is just what you need to hear when you've just finished a very long book on the subject. One of those two individuals is here today. Today, I'm a partner at a law firm, mainly acting for rights holders, and I'm delighted to come and talk to you about what my view is on exhaustion and how that's changed over the years. There's really two topics I want to touch on today. First off, what are the rules in EU or EEA exhaustion? Because I think it's a topic that most IP lawyers think they kind of know, but aren't really very comfortable about. And my first point is, it's dead easy, and here's all you need to know. Secondly, I'll look at a few issues which are a bit tougher and where they're more complicated. So starting off with the easy bit, so you can go to sleep for the second bit if you like. The only question you need to remember is, was the product put on the market by or with the consent of the right holder within the European Economic Area? If you remember that rule, which is in all the cases, and it's in the legislation, if you remember that, you've kind of got the answer. Okay? So that means under the EEA agreement, under the Treaty on the Function of the European Union, we have exhaustion for anything put on the market in the EEA by or with the consent of the right holder. What about international exhaustion? What if it's put on the market outside the EEA? Well, that's not a question for the Treaty on the Function of the European Union or the EEA agreement. They're about trade within the EU, within the EEA. But that's provided for in the secondary legislation. So that's provided for in the Trademark Directive. That's provided for in the Designs Directive and so on. It's not provided for in patents, subject to whether the UPC ever comes in or not. We have to say that at some point in every talk at the moment. But patents are still a matter for national law in terms of international exhaustion. So each country has its own rule in exhaustion of patents. But that's really it, okay? So if you really don't want to hear very much about exhaustion, that's all you need to hear. Right, where are the difficult areas at the moment for EEA exhaustion? Well, they can break them into three. First off, can the right holder circumvent EEA exhaustion? Right holders, we've heard, don't like exhaustion. There are good reasons why rights holders don't like exhaustion. Can you get around EEA? Secondly, can the importer circumvent the prohibition on international exhaustion? So can I import goods from outside the EEA into the EEA and somehow get around that prohibition? And then thirdly, what I sometimes describe as exhaustion on steroids. To what extent can the importer change the trademark and say, yes, I know you put that trademark on it, I don't care, I want to put another trademark on it. To what extent can you do that within the EEA? And I think those are the three most interesting points that arise on exhaustion. First off, can the right holder circumvent EEA exhaustion? Well, what if the products are different? Well, the ECJ says no. What if the rights are different? I've only got rights in some countries. No. What if there are different regulations in different countries? No. What if there are different pricing rules in different countries? No. What if I have a contract that says something that they can't import? No. And you're probably in breach of competition law at the same time. What if I set up a group structure and have different companies in my group putting the product in the market? No. None of that helps you. Where do I get any help? Well, if it's relabeled pharmaceuticals, that might damage the product in some way and confuse consumer. And the ECJ said, well, generally, no, that's not good enough either. As long as people comply with the rules, we'll set out the rules, but you can basically comply with them. The only area of light for the rights holder is on assignment of rights. If I assign the rights in some countries to a third party, and I no longer have a contractual relationship where I control the rights being put to the market and vice versa, then it appears that I can block imports. I can block imports from my assignee, and my assignee can block imports of my goods. And that we found that out in IBIL standard, and that was applied in the UK in Flynn Pharma. But then we got Schweppes. And Schweppes says, well, actually, sometimes I'm not sure that's right. If it's really still being branded in the same way as a global mark, maybe not. Maybe even in that case, we will say there should be exhaustion. So very, very strong. There should be exhaustion within the EEA. All these clever attempts to get around it don't work. Okay, so that's within the EEA. What about on the other foot, the poor importer trying to import from outside the EEA? Well, we have the Silhouette case, where they said the Trademark Directive doesn't actually change things. It's the same rule. It's national rule on international exhaustion. And the ECJ said, no. The Trademark Directive harmonises it. And I would point out, at the time we were having all the rip-off Britain commentary, one of the things is, why did we sign up to this? This is ridiculous. The UK signed up to the Trademark Directive. They signed up to the rules on international exhaustion, which prohibited it. So Silhouette said it wasn't. Sebago tried a clever way around it. They said, well, exhaustion applies only in relation to once a particular type of product is in the market, all rights are exhausted. So once that pair of shoes has been sold, then all pairs of shoes can be imported. They said, no, that's not what we mean. The UK courts had, in the Tesco-Levi Davidoff case, the English courts had a shot at trying to find a way around it. They said, wait, we've got this English doctrine of implied license, and that allows exhaustion, and we should apply English rules even though this is meant to be EU rules. ECJ, yes, nice try, but no. The prohibition is a matter of community law, and it should be the same across the community. Most recently, and I think many people think most outrageously, we had the Mitsubishi decision. And the Mitsubishi decision says, well, what if we take off all the rights? We remove the trademark from the goods. Surely we can then import them into the EU. And the ECJ said, no, you can't. That's infringing trademark rights. You've removed the trademarks that were on the goods. If you'd left them on, you wouldn't be able to import because you'd be infringing the IP rights. But removing them also infringes the IP rights. You still can't import them. Great result by Mitsubishi. Slightly hard to follow from an IP perspective, but there we go. And then finally, the question is exhaustion and steroids. And this idea, can the importer change the trademark importing from one member state to another? And the answer there we've got is, well, yes, if it is necessary to access a significant part of the market, you can change the trademark. And that seems, again, very odd to most IP lawyers. The example I always use of this is Kellogg's say they don't make breakfast cereals for anyone else. If they did, could a bright spark parallel report say, that's very good, I've worked out Kellogg's are making these cornflakes, I'll now slap Kellogg's in the box. I know it says Aldi on it, but I'm going to slap Kellogg's in the box. IP rights, most IP lawyers will say, well, no, that doesn't make sense. But the law we've got says, actually, no, that does make sense when it crosses border. You're allowed to change the mark as long as it's necessary to access a significant part of the market. And that's been upheld in the Court of Appeal in Specialty in Doncaster. It's been upheld in the Court of Appeal in Flynn Pharma. Neither of those cases went to the Supreme Court. So that's the law we've got in the UK. Different member states have taken different approaches in the Belgian courts and the Vartus. The courts have said, no, that doesn't make sense. That's not really the same market you're talking about here. And I think there's a level of discomfort with that, but that's where we've ended up. And so, if we take back, we've got this very straightforward, was the product put in the market by or with consent of the right holder in the EEA? And the courts are not interested really on either side. When it's within the EEA, I'm not going to let you get around that unless you sign your rights, and even then, I might have some problems with it. If you're outside the EEA, I'm not going to let the importer get around it, even if they take the rights off the goods. And so with this really quite clear, and we more or less know what the rules are, we decide, let's get rid of those rules and let's have a new rule for the UK. And let's give the IPO the lovely task of trying to work out what that new rule should be. I'm not going to preempt the next speaker by telling you what that rule should be, but that's the framework within which the poor IPO has to make its decision.
Thank you very much. Good evening to everybody. I would like to start by thanking Professor Sir Justice Robin Jacob for inviting me and putting together this great panel on a topic that is not exhausting, it's actually very interesting. I thank Lady Justice Rose, I thank my fellow panelists and all of you that are here tonight. It is my very pleasure to be back at the University of London, where I have been studying 20 years ago and where a lot of my passion for this topic started, because it was indeed the classes on the LLM on intellectual property, and back then the decision that Lady Justice had referred to the ECJ, now the CJEU, that started my passion for this topic. And Chris, I want to say something about your long book. When I was editing, start to edit my research and book on IP exhaustion and parallel imports, Jeremy Felix, that was back then the general editor of the Elgar Research and Book series, I didn't know you personally. He asked me, you have really to include Christopher, who just wrote an amazing book on exhaustion, a very long one. So you see, you might not know the story, but your book was very appreciated by many in the field. So as I mentioned, the passion for me for this topic really started here in London when the European Court of Justice was responding to some of the questions that Lady Justice had referred to try to understand the impact of Article 7 of the directive, first through Silhouette, then Sebago. There was a string of cases back then. When I moved to the United States, and I am today a professor in the United States as well, I continue to work on international trade, also in Europe and in Asia. I started by looking at this issue, and back in the early 2000s, the situation in the United States, and I've been asked to talk about that here tonight, was we had national exhaustion for patent, we had national exhaustion for copyright, and international exhaustion for trademarks with some twist with respect to material differences in product. To a large extent, the trademark approach was similar to what the United Kingdom had before the European Court of Justice, through the trademark directive, harmonized the system through a European-wide or EEA-wide exhaustion. But I think a lot of the discussion on exhaustion and a lot of the discussion that we have through the FTAs, through the TRIPS agreement, I think there is provision in the GATT agreement that precedes TRIPS that are also interesting to look at. The discussion that Britain might have, if or when Brexit happens, what should Britain do? Stay with a community-wide exhaustion or go back to international exhaustion, or what are the options? Really goes into this relationship between international trade and movement of goods. In the European Union, we have really been looking at this issue ever since as an internal market. So movement of goods as one of the fundamental freedom for the internal market. And when I arrived in the United States, as I said, the situation was considerably different than what it is today. We had, in 2013, a decision, Kirstensen, and in 2017, another decision by the Supreme Court in Lexmark. I'm going to go into very brief details in a minute. And both the decision rebalanced, changed the law, clarified the law, because neither the copyright statute nor the patent statute have a specific provision on exhaustion or for sale, as it's called in the United States. In the statute, but the court interpreted the previous case law and somewhat the contradictory previous case law to say there is now an international exhaustion or international first sale. The first sales outside the United States exhaust the right as if it happened in the United States. So back to this principle almost of universality versus territoriality. And to a large extent, we can see that as a movement of the court to rebalance all this international trade. We see manufacturing happening abroad, pieces of goods done left and right, and at that point, tariffs being reduced tremendously. So at the same time, we have this outsourcing and international global trade that still wants to be controlled through territoriality and pulling the strings of international trade by preventing reimportation without authorization. And perhaps in the interest of global competition, the Supreme Court in the United States said that that has to change. This type of international trade reflection were not very well developed in neither of the decision of the Supreme Court. In fact, Justice Ginsburg, if any way she dissented in both cases, she highlight the highly territoriality approach of intellectual property. But something is to be said about global economy changing, and to a certain extent, the Supreme Court doing something very different than what the current United States administration is doing. The United States administration is bashing international trade, but the Supreme Court certainly has been embracing international trade to a level unprecedented before. So the point I'm going to briefly make is now we have international exhaustion in the United States as a rule for all IP law, with, again, some twist, particularly in the trademark area. When we have products that have material differences, they can be blocked unless they're properly labeled under the Custom and Tariff Act in the United States. However, overlapping rights, so when we have the same goods protected under copyright or trademark or both, or they could actually be leveraged in different ways, primarily now leveraging trademark law over patented or copyright products to try to prevent reimportation based on these material differences and lack of proper labeling. But my last question is, does this matter? Because this is a fascinating topic for our academics and is a never-ending topic. But in reality, we know that contract licensing, first of all, many products today are no longer sold. They're just licensed. And contract can often override international exhaustion provision by putting restriction in further sales. And any sale, any products that get reported against this contractual obligation can be considered an importation in breach of contract. And so does this matter? Moreover, particularly for the publisher, digital exhaustion, again, doesn't involve an actual sales of a physical good. And in the exhaustion, the principle is you put the product into the market, they circulate, they move. You have no longer the same products in the same place, while when you have transmission through digital means, you have copies made. So you don't have the self-destruction of the first copy, you make a copy, so there is no exhaustion of the first copy. And so with a world that is moving towards a lot of digital information, digital transmission, and contractual obligation, licensing versus sales, what we are talking about here certainly matters, but matters less than sometimes what we academics might think. So very briefly, I'm going to mention Lexmark. Lexmark was a case decided by the Supreme Court in 2017 that was about cartridges for printers and whether other company could how could you resale these, some of these cartridges, and this was a sale made abroad, and under a vacuum in the law, the Supreme Court said, yes, a foreign sales exhausts the rights in the patent, also for the United States. So international exhaustion. However, the Lexmark decision doesn't address specifically the question of post-sale contractual obligation. And so it's unclear after Lexmark, and that might be the next question that the Supreme Court might be asked and might take on to further clarify the issue, but it's pretty clear that the court intentionally didn't want to address this issue at this point, whether post-contractual sales restriction, so contractual sales, post-sale restriction will actually be possible to enforce them. In copyright, the Kirstensen decision of 2013 intervenes after a complicated situation of interpretation of the copyright statute. The copyright statute in the United States talks about goods that are lawfully made under this title. Doesn't say where is lawfully made, where this title means the United States or abroad. We had a decision about shampoos. Not really, again, this was a decision because trademark exhaustion was international, so how can I block shampoos or importation, trying to use copyright over the actual tags and warranties and labels on the shampoos. And in that decision, the Supreme Court said that because the sale was made in the United States, then the products were exported away and brought back in, they were lawfully made under this title. So it was this round trip. But then this, of course, still left the question, what if the products are made outside the United States? Are they lawfully made or not? And so in another case, this was the decision. In another case called Costco versus Omega, again, a copyright case, but really a consumer goods trademark case that used copyright as an overlapping rights. An equally divided court, because Justice Kagan couldn't be part of the panel, of the bench, because she was the Attorney General when the case was argued. An equally divided case said that lawfully made under this title still may, as the lower court said, meant made in the United States. But that brought us to still the question pending, and these goods were made outside the United States, and they were brought back. And finally, Kirstensen in 2013 was a decision now not about overlapping rights, was a decision about textbook. I know my colleague here might disagree with my position. I think this was a very good decision. Here, the books were brought back from Thailand by this very entrepreneurial medical student, and the court said the lawfully made under this title meant made anywhere in the world. So the sale was, as long as the sale happened over lawfully made books or lawfully made articles anywhere in the world, was exhaustion applied, and the goods could re-enter. And finally, trademark exhaustion in the United States is based on statute, but what happened in the United States is, like in the United Kingdom before the European Directive on Trademark, we have the rule according to which goods, because trademarks are supposed to identify source, when the source is a legitimate source and the trademark is truthful, different than copyright and patent, this concept of territoriality doesn't apply in the same way, unless, though, the goods are of material differences. I've written extensively about how multinational change the quality of the goods, specifically to bypass and trying to block the goods from moving. We know in the European Union we have the principle of mutual recognition and then harmonization of standard, through which even if goods are of material different quality, they can still move around because freedom of movement, the movement of goods prevail over the quality, the differences in quality. But in the United States it does not, because people can get confused. How can we dispel confusion? Through disclaimers. According to the Custom and Tariff Act, if the goods are properly labeled, then these goods are going to be they can still enter. And so now, after Kirstensen and after Lexmark, whether trademark can be used, again, as an overlapping rights over the fact that the Penguin books have the pages that are different in the type of paper, one more based on plastic or the other one based more on paper, cellulose, the percentage, and so on and so forth. Can we block these products? And at this point, the question is, sometimes yes, sometimes no, it depends how they're labeled. And so, here, I close, and I, a bunch of specific, so this was the rule in the United States, but, some of these material differences are, to me, quite ridiculous, like tomato from Canada are different than tomato from the United States, so the Heinz ketchup bottle got blocked because they were not labeled. Contractual restriction under US law, or those not for resale in a specific jurisdiction, the courts have interpreted those inconsistently. Sometimes they say these are blocked or they are legal import or they are infringement. So, after Kirstensen and after Lexmark, what really remains the issue, this is the gray, we talk about gray markets for parallel imports, is the world in the United States remain less gray, but still quite gray. And the question I think would be nice to talk to you all about today with possible question is, in a world of global economy, in which we disseminate things left and right and we produce them left and right, Why should we be able to block them unless we have a consistent price discrimination that really helps the poor country, and we really don't have empirical data that prove that? And with that question, I thank you very much.
Good evening. I should probably start with the obvious caveat. This is not a comfortable time for a civil servant to be talking about Brexit. Please tell me that's not government policy changing. When I turn my phone off at 6 p.m, the UK government policy remains that the UK intends to leave the EU with the Prime Minister's deal. Obviously, events in Parliament mean that other options are in the running. So please bear with me if there's questions I can't answer at present. So why are we interested in exhaustion at the moment? William asked the sort of very good question that why are we messing with the status quo that works? And most people do actually like the current system. It's a balance. Rights holders that we've spoken to mostly know how it works, and it's grown up over the years to reflect the balance of interests that are at play. But there's a compelling reason why we've had to act now, and that's, of course, that the legal basis for exhaustion, which is a mix of treaty rights and statute, will not survive EU exit. If some of the directly effective treaty rights are repealed, which they may well be in time, then that has an effect on exhaustion. Where exhaustion is directly referenced in UK statute, such as Section 12 of the Trademark Act, it usually refers to goods being placed on the market in the EEA. Under the current plan, we aren't going to be part of the EEA going forwards, so obviously those references will not work. So we have to make some changes for legal certainty to ensure that the rules work and that everybody knows what they're able to do. So some people have asked me why exhaustion was not negotiated as part of the withdrawal agreement. And the answer is that it was, but only up to the point of our exit from the EU. The draft withdrawal agreement states that IP rights which were exhausted in both the EU and the UK prior to our exit remain exhausted in the EU and the UK after exit. So that gives certainty for people who are trading in goods, who may be shipping goods up to the moment of exit. Once those goods are on the secondary market, they don't suddenly become unexhausted the day after exit. But we're concerned as well with what happens at the end of the transition or implementation period. And that's a matter for the future economic partnership, and those negotiations haven't yet started. It's easy to forget with all the current discussion about the deal that the current agreement on the table is just literally about our separation from the EU. It doesn't define our future relationship, and in fact it leaves the door open for quite a wide range of possibilities within the scope of the political declaration. And if you've been following the news right up to the end of this afternoon, you'll realise that the political declaration has now been decoupled from the withdrawal agreement as well. So will exhaustion be negotiated as part of the future economic partnership? At the moment, that's not something I can really make any predictions about. There are a lot of options for what the future relationship might look like. If it's a fairly arm's-length relationship based on a free trade agreement, you might expect normal free trade agreement language to apply. Free trade agreements usually leave exhaustion up to the parties to decide, although it's probably worth noting that recent EU free trade agreements have tended to limit the options to national or regional. If, however, we end up in a closer relationship that includes free movement of goods, for example, through membership of a customs union and high alignment to the single market, then it may be that exhaustion becomes more relevant. After all, it would make little sense to have free movement of genuine goods limited by IP rights in that context, at least when it gives arguably little benefit to rights holders. All I can say is that we will work to ensure as many of these considerations as possible and the views of stakeholders are taken into account as we develop the negotiating mandate and strategy. So that covers the scenario where we leave with the Prime Minister's preferred deal, or one like it, and then negotiate a future relationship. But what about if for one reason or another we leave with no deal? Well, the government and Parliament have both expressed their view that this would be extremely undesirable, but preparations have been made anyway as the responsible thing to do to limit the damaging effect as far as possible, just in case it does come to pass. The Intellectual Property Exhaustion of Rights EU Exit Regulation 2019, which is number 265, if anybody wants to look it up, is intended to ensure that there will be continuity past the exit date in the event of a no deal, and the position on exhaustion of rights for parallel goods coming into the UK will be the same on day +1 as it is immediately prior to exit. There may, however, be restrictions on what can be exported from the UK to the EEA on the same basis, but that's a matter for EU law and not something we can directly control. We published a technical notice on the 24th of September setting out the no-deal position and what UK businesses need to do to prepare. That explains in a little bit more detail how the SI works. But what are we trying to achieve with this legislation? To be honest, it's a bit of a sticking plaster. We needed to do something to fix the legal framework before exit, and the legal vehicle we had was the Withdrawal Act. The powers in Section 8 of the Withdrawal Act are quite narrowly cast, and they are only intended to allow us to fix anything that breaks during the process of rolling over EU law into UK law. The powers in the Withdrawal Act are not intended to be used to make substantial policy changes, such as a change of exhaustion regime, and we're not yet in a position where we know what future regime we might want to change into. During debates in Parliament, quite a lot was made of the fact that this sticking plaster approach results in a slightly one-sided exhaustion arrangement. And it was claimed that this unfairly disadvantages UK businesses compared to their EU counterparts. That's not correct in our view. As those of you who deal with IP rights in your work will know, it's very common for UK businesses to hold rights in other EU member states and vice versa. So there is a one-sided effect, but it applies to businesses moving parallel goods from the UK to the EEA as opposed to those moving them in the other direction. What is important is not the nationality of the business, but the direction the goods are moving. Concerns were also raised in Parliament that the exhaustion system after exit would not be identical to that before exit, therefore retained EU case law might not apply, the silhouette judgment being one commonly quoted. Obviously, if that were true, then the legal system would be changed, and it's possible that we might get international exhaustion by the back door. We believe these concerns, again, are unfounded, based on a misunderstanding about how the Withdrawal Act works. Section 6 provides for the interpretation of retained EU law, so far as that law is unmodified after exit, to be done in accordance with EU case law, which would include the silhouette judgment. Whatever exhaustion regime the EU adopts after exit will not be a modification of our domestic retained law. So the imbalance that's created is as a result of the EU changing its exhaustion regime or the boundaries of its exhaustion regime rather than the UK making any changes to its exhaustion regime. So the retained EU case law, such as the silhouette judgment, will still apply. So that's the situation for no deal, but we're obviously trying to avoid that. So what happens if the Prime Minister's deal, or one like it, is adopted and a future relationship is negotiated which does not dictate anything about our exhaustion regime? Everything's to play for. Well, in the first instance, we'll probably need another sticking plaster. The transition period or implementation period is intended to run to the end of December 2020. And then the same issues with regard to treaty rights and statutory references to the EEA will occur. The no-deal SI that has been passed already will not apply in the case of exit at the end of an implementation period. But we will need something similar to ensure legal continuity at that time. Now, it might be by then we understand and we have a good idea of what new exhaustion regime we want to move to, and we could use legislation at that point to bring that regime into being. It's equally possible, however, that we'll still be grappling with this and we'll still be trying to understand what the best approach will be, in which case a continuity approach like the one we are taking in the event of no deal would be the most sensible option. So how are we going to decide on that new regime? It's difficult. We're currently considering all of the options. Nothing's off the table. The legal and economic arguments are extremely complex and finely balanced. And so we've commissioned a feasibility study to inform the assessment and the analysis of our options. You've heard William make a very eloquent case for why the publishing sector has concerns about any move to international exhaustion, and we've certainly noted the benefits that that sector sees in a national or regional approach. But we have a responsibility not just to rights holders, but also to consumers, the public sector, and to other businesses. It's hard to talk about this stuff without oversimplifying very complex arguments, but obviously some argue that an international regime offers greater choice to consumers and lower prices. That's not true for every sector or every type of good, and it may be that books is one of those exceptions. We also have institutional purchasers like the NHS who greatly benefit at present from the ability to source medicines from anywhere in the EU. Changing to a national scheme would have real cost implications for them, Again, William has noted that the cost may be more than offset by the effect on other sectors, but that must be considered in the round. And there's also issues around safety and security of supply. The ability to source pharmaceuticals from a wide range of countries actually gives additional security to the NHS in that sense. So it's not an easy problem to solve. We want to get it right. So we're going to take the time we need to develop an evidence base. The feasibility study that we've commissioned has now been completed. We're hoping to publish it soon. And that was intended to look at what existing data was out there and look at the feasibility of gathering enough data about parallel trade, costs and impacts to make proper policy decisions. It didn't carry out an analysis of the different regimes. It doesn't make policy recommendations. So when this is published, it won't say we are going for, or we should go for this type of regime or that type of regime. It's just looking at whether we can do the research that will be needed for that next step. And the findings of the study, without giving too much away, suggest that that's going to be difficult. No great surprise. There's very limited data out there on parallel trade on the extent and scale. It's exacerbated slightly by the fact that a lot of businesses don't understand whether they are parallel importing or exporting. Where they are, they may be unwilling to share that data for a variety of commercial reasons. But we have to get into that and we have to understand how it works if we're able to make, or going to be able to make some robust policy decisions. So obviously the response to the report and any further policy development after that will take time. There's no compelling reason to rush while we've got our sticking plaster in place. So we're going to gather all that evidence, look at the likely impacts, and listen to businesses and consumers and other stakeholders. Whether we get a deal or no deal exit, we're going to try to ensure as much continuity as we can for businesses and consumers while we take that time to determine the best way forwards. We'll be looking for business sectors such as the publishing industry and others to help us build that evidence base. And we'll take whatever time is necessary to make the best decision that we can. Thank you.
Thank you very much for very different but fascinating talks from our speakers. We have about 10-15 minutes for questions, if that's all right. Who would like to kick off? Yes, gentleman there. Oh, we have a roving mic, of course. No event is complete without the roving mic.
This is a question, I think, primarily for Dr. Stothers. Given that, as you say, in the European Union, the present rule is that once it's been placed on the market, then that's exhausts the right within Europe. All things being equal, assuming that Europe doesn't change the law retrospectively or otherwise, that of course means that articles that have been previously placed on the market in the European Union, that today are placed in the market within the UK, will continue to be freely tradable within the European Union. I assume you'd agree.
Yes, that's my understanding of the transitional agreement, and that would be my understanding of what would likely be the outcome even without that. But there was a lot of fanfare about we've done a deal in Exhaustion, and it said, well, this is what happens up to the point at which it is leaving, which is yes, it's okay, it's a deal, but it doesn't tell us very much.
Do you want to add anything to that?
No, other than that's exactly right. That was as a result of the way the negotiations are structured. We're not able to have those conversations about the future relationships. So the withdrawal agreement just deals with up to that day of exit.
Yes, gentleman there.
Hi there. Question from Matthew Cope. The withdrawal agreement provides, in relation to exhaustion, that the rights must be exhausted both in the UK and in the EU. Does that mean that if the rights have been exhausted only in one jurisdiction but not the other, then they will not be exhausted?
It's an interesting point. I'm struggling to think of an occasion where that would happen, given that the scheme is a regional one at present.
Do you have a particular instance in mind?
Well, I was imagine, say, if goods are put on the market, say, for example, only in the UK with the consent of the rights holder, you get to the end of the transition period. I'm assuming then that the rights will not be exhausted in the EU, it refers only to the EU, not the EEA, and similarly vice versa if the rights are exhausted only in the EU, but not in the UK. In the transition period, they cannot be, they won't be exhausted in the UK.
But I think if they're put on the market in the UK before that moment of exit, they'll automatically be exhausted in the EU as well, which is the effect of the current system. So it is slightly odd wording covering it from both sides, but I can't see how you would end up not triggering both.
Right, and the point also, of course, the withdrawal agreement only covers the EU
Sorry,
and
could
not
you
the
speak
EEA.
up a bit? We can't.
Sorry, the withdrawal agreement only covers the EU and not the EEA. So, again, if the product is placed on the market in Liechtenstein or Norway.
Yes, that's true, and other arrangements are needed to make that clear.
Thank you.
Maybe just picking up on that point, I mean, we already have that issue for patents because the question of exhaustion is national. And that's one question people sometimes raise is, well, if it's international exhaustion in one of the member states and the good comes in there, is the right exhausted across the EU at that point? So if a parallel trader, let's say Austria applies international exhaustion patents, is the patent right exhausted by someone bringing it into Austria? And the answer is obviously, look back to the one question, which is, was it put on the market in the EEA by with the consent of the right holder? The answer, no, therefore it's not exhausted in the EEA. It may be exhausted in Austria, but that's a separate point. So you already have the possibility of differential exhaustion regimes within the current system.
Thank you. Any further questions? Yes.
Hi there. This isn't directed to any particular person, but one idea that I've heard floated, which I'm not endorsing myself, I'm staying definitely neutral on it, is that you have a sort of sector-based approach in relation to exhaustion. So in relation to pharmaceuticals, where there is a need for rights for international exhaustion, you could have that regime, but perhaps for books and the publishing industry, you have a national regime. How do the panel feel about that? Whether it would work in practice?
Yes. Who wants to? Irene, do you want to say something about that?
You already have some jurisdiction that apply this approach. Indonesia does that in the new patent law. The Philippines does that. Singapore itself, after the FTA with the United States, has a specific provision that is in favor of international exhaustion for patent in general, but for pharmaceutical has a specific provision that provide for enforcement of contractual restrictions that don't apply on the other side for all other goods. I think it's tricky when we think about pharmaceutical is a very specific industry, and not all pharmaceuticals are the same also within that industry. You have prescription medication that tend to be much more heavily negotiated in price by government versus non-prescription medication. Just an example is in the United States, ibuprofen or aspirin, even when we had national exhaustion for patent, were very cheap. You can buy 200 pills for $10 or less, while the same aspirin is very expensive in Italy or very expensive across European Union, but then the actual antibiotic or prescription medication are much cheaper, and that is because the different type of negotiation versus insurance, private versus public, system of healthcare, universal healthcare, and so on. So I think it really might depend on a case-by-case basis. It's hard to predict.
So what are the criteria for deciding that a sector should have national or international exhaustion?
Well,
Sorry, William.
thank you. Now, if I may make a sort of non-IP point, I would suggest that the government should think about what its trade and other policy needs are for particular types of products and services, and then work out what policy measures best implement that, rather than what exhaustion system should we have, and then, oh, no, there's going to be implications. Now we're going to have to scrabble around. So I think starting from that, what books do we need, or what other things do we need? How do we get that? Is this a good thing? Based on whatever criteria those might be, and they would be different for different sectors. Then how do you maintain what you want? And so I'd like to hope it could work. I think different splitting by IP right and different IP rights in different products, that could get very complicated. So maybe something that's based on products with really clear ideas about this is what we need could be a way to do it. And we're open-minded to what it would be.
Thank you.
Can easily become a protectionist system. You are going to have national exhaustion for your own national products that you produce and not. Big country might be more able to do that versus small country that might be obliged to follow certain specific rules regardless, or also in certain sectors, say pharmaceutical for Singapore, not because of interest of Singapore, but mostly because of interest of the United States in the FTA. Same interest of, the European Union, the FTA. And so it might really depends down to a negotiation and national interest versus national interest beyond that specific products in IP, maybe national interest about international trade or defense or other factors. And I think it's very difficult to generalize. It needs to really go down to case-by-case analysis.
Yeah.
Gentleman at the back there.
Yes, it follows on from the previous point, really. My understanding, for example, of the Swiss system for patents is that they have international exhaustion except where prices are fixed by the government in their case, and that has the effect of precluding international exhaustion for pharmaceuticals and presumably for medical devices as well. So that seems quite a neat way of approaching it.
Any students here who'd like to ask a question? Mostly been the oldies so far. Young woman there.
Hi, my name's Georgia. I'm from Queen Mary. Irene, you kind of touched briefly on this. You were talking about digital exhaustion and how perhaps the conversation we're having about international or national isn't even something we should be considering because of the tangibility aspects of digital exhaustion. And I just wanted to know, do you think the conversation of digital exhaustion is even relevant? Given that we no longer have objects, it's more of a service-based industry. So yeah, I'd like to hear you speak a bit more about that, if that's all right.
William, do you want to?
Yeah, so a couple of things.
Where is if I'm watching a movie on an aeroplane, where is it being placed on the market?
That's a good question. One of the reasons why the issue of exhaustion is so important for books is because there's still a disproportionate, compared to many other content industries, a disproportionate amount of physical product. And that's driven by customer demand rather than, for example, many of you will be have access to academic journals, which is a 93% digital space and has been for 15, 20 years. But in trade fiction books, many of you still choose to buy physical products. So we have, in publishing, a disproportionately physical-based industry, which is why this issue around goods is so important. On digital, all I would say, obviously there's a case, there's a hearing next week in the Tom Cabinet case in the EU on Tuesday, I think it is, so a very important case next week, and I would suggest you, obviously that's going to be a key moment. Look, clearly a system whereby publishers could only get paid for the first copy would be crazy. So we have to find a way, again, coming back to my point about let's decide what we want. We need, and in the UK, for example, recently there's a system called PLR, so authors get paid for lending in public libraries, and that last year was extended out to include e-lending, so that authors can get paid for digital rental. And DCMS and other colleagues in the civil service spent good time working out a way of balancing this so that that could still happen, but that still authors would get paid for books that were published. So there are ways around it. I would say focus on what the outcome should be, rather than thinking, how do we get this exhaustion principle to work in a digital system from a business perspective? I think that's the wrong way of looking at it. How do we ensure that people can still have high quality products and services in a digital space? And then let's work out what IP policies we need to make that happen as well.
And have they been addressing this in the US, Irene?
So I think it's interesting if you are familiar with the Oracle case in the EU and the Redigi cases in the US. The Redigi cases actually tend to be more conservative and say that there is no exhaustion because there is copy. But that has been one of the issues that the Copyright Office has in the United States issued a big report, and one of the issues is that one. We do talk about digital exhaustion considerably, and one Max Planck is also doing here in the European Union's considerable amount of work. on see how and if we can fix, some proposal is self-destruction. If you transfer a file, the file will be basically deleted, self-deleted from by the server in the very first, you are the sender that you don't keep a copy. Again, a lot of these issues are taken away with the licensing and the contract. Those tend to be transnational. Then you still have problem of adjudication in case of conflict, because in that William and I might disagree about some issues, but I actually know that the price differentiation of digital books in India is considerably cheaper on a national exhaustion basis, and that's really proven to work in terms of dissemination of cheaper books and more access to education. So how can you look at that? I think it's great PhD dissertation, and there is lots of work, and I understand there is a case again, and in the United States we are going to talk more about that.
Can I just say one thing? I mean, it's really sad if publishers want to be able to trust their customers. The notion that we have to start fearing that all our customers want to be pirates rather than people who just want to read our products isn't a happy place to be. And it's just about giving us confidence in a framework and a system to know that we can continue to invest in digitising and changing our output and doing it in a different way and meeting what customers need. So again, I hope there's a pragmatic compromise. It's often presented in very binary terms.
Can I maybe add one further point? I mean, this is an issue I got asked a lot about when I was writing my book, was what's the digital exhaustion perspective going to be? And there was virtually nothing on it at the time. We had one case about iTunes floating around about that, and whether the pricing in Europe was the same, which I always explain. There was differential pricing. Apple promised they would level the price, and so they changed currencies so that the price changed by the currencies changing rather than Apple doing anything to the pricing, which was pretty masterful. But I think it's right that it ought to be decided at a policy level, and it should be a policy decision. At the moment, we have a slight problem because the policy lobbying has been very one-sided historically. So the legislation is quite against digital exhaustion. The court doesn't like it, and we see in cases like Murphy and Usoft that the court really bends over backwards to allow digital exhaustion in some shape or form. And so we've got a bit of a policy tension where there was a policy that possibly wasn't as balanced as it should have been. The court then decides, well, I don't like that, so I'm going to make up my own policy. And you end up with court-driven policy, which I don't think is good for anyone. And so I think right, absolutely right, but it's a difficult policy because it needs to be balanced. Otherwise, it just won't stand up because there's single market issues and competition issues which can override whatever the apparent policy decision made was.
Yes, so that's another thing for you to put on your list of things to do, please, Matthew, to sort that one out. I think we'll draw this to an end now. It's been absolutely fascinating. I know Robin wants to say a few words, but I'd just like to thank myself and on behalf of you, the speakers, for this is obviously a fast-moving area. There's a lot going on, both technologically, legally, politically, and we've had a really excellent overview from so many different perspectives this evening. Thank you very much. Sir Robin.
A great panel, great panel. Thank you very much for coming.